Hello?
Yes, Honorable Martin. You're connected.
Good morning, honorable members, colleagues, honorable stakeholders. It's Monica from NCOP Liaison Office. Thank you.
Morning, Ms. Maroa. Colleagues, we will be starting in about 2 minutes now. We're just waiting for the last people to connect. We'll be starting in exactly 10:15.
Hello.
Good morning, honorable members. Allow me to take this opportunity to welcome everyone now. We are about now to officially start with our meeting. Can we have our IT team uploading the agenda? Once again, I would just want to re-emphasize that we are now live on YouTube Live, and I want to re-emphasize that we may need to keep the etiquettes of the meeting. We may need to hold ourselves in a manner that represents and protect the esteem of this meeting. But most importantly, to say to everyone, you are welcome, and then feel free to engage in this public hearing. We want to indicate that and to say we think we are ready. Our team has been, support staff team has been working overnight ever since last week to ensure that we find ourselves organized in this way. From my side, I'm very, very confident that we are well organized can carry forth with this public hearing. And I want to take this opportunity to welcome honorable members who have joined us here. We have been joined by honorable members. We have been joined by the support staff, and we'll also be getting an indication as to who else is here. In our part, all the honorable members are here, and then I want to take this opportunity to welcome them. The various establishment of our support staff from the IT, from the public hearing support, and also from communication, liaison officer from the National Council of Provinces, and everyone. I want to welcome all of you. And I hope we're going to, I hope and strongly believe we're going to have a successful public hearing. As indicated, we are meeting today at in a venue which is virtual at about 10:15 on the 30th day of September 2020, as we close the Heritage Month today. On this Portfolio Committee on Economic Development, Environment and Tourism, on the public hearing for the two bills, the National Forest Amendment Bill and the National Environment Management Laws Amendment Bill. With these few words, colleagues, I want to welcome you, and I'm going to request that we do the introductions, who's here, and then we'll do it in this way. Ms. Malawi will indicate the committee members that are here. From there, we'll have someone will have to introduce support staff that are here, but we'll also want to confirm how many stakeholders have confirmed and have actually joined, because that will be the basis upon which we'll be moving forward. So without much ado, colleagues, Ms. Malawi, if you can introduce honorable members we have joined.
Good morning, Honorable Chair. Good morning, honorable members. We have got the following honorable members at the moment: Honorable Mate MS, Honorable Pala KA, Honorable Smale J, Honorable Makrupeche MG, Honorable Masikwameng will join us very soon. He was still struggling to join. Thank you, Honorable Chair.
Thank you very much. Let's assist the Honorable Masikwameng to join, and then if I can get an indication from the support staff who's here, Dr. Mzana.
Thank you, Chairperson. It's Ms. Molepo, public participation. Mr. Mzanana is attending another meeting. So I am with Ms. Lekeke from public participation. Thank you.
Okay. Thank you very much. Communication.
Good morning, Chairperson. Ms. Carol Slona from Communication Services.
Thank you very much. IT support.
Good morning, Honorable Chair. At the moment, we have Refilwe Mudiba from the IT section and Ms. Machubeng. They are here. They are assisting us at the moment. Thanks.
Thank you very much. They are also welcome. Who else? NCOP, Lizen. Ms. Maroa. Is Ms. Maroa here?
Yes, Honorable Chair. Mr. Neroyeni as well and Ms. Marocha.
I'm sorry. Good morning. I'm back, Honorable Chair. Good morning. And good morning, honorable members, and good morning, colleagues. It's Monica Maroja from NCOP Liaison Office. Thank you.
Thank you. Ms. Malotsa?
Good morning, Honorable Chairperson. I am here. I'm Barbara Malocha from Legal Services.
Thank you very much, Ms. Malotsa. Mr. Noluweni, our research office.
Good morning, Honorable Chairperson, Honorable members, colleagues, and the stakeholders. I'm Katshiro Neruheni, Portfolio Committee Researcher. Thank you.
Thank you very much. Thank you very much. I hope I've covered everyone in terms of the colleagues who are supposed to be here and honorable members who are supposed to be here. Without much ado, I would want to get a confirmation of the stakeholders. Ms. Malawi and Ms. Molepo. Ms. Molepo.
Oh, thank you, Chairperson. I think we have about 5 stakeholders. I'm not sure if maybe they may introduce themselves, but I can introduce Dr. Dima, because he's not using the smartphone. He may not be able maybe to raise his hand. Thank you, and others may introduce themselves. Thank you, Chairperson.
Okay. Honorable stakeholders, in that order, Dr. Dima, you are welcome to this virtual public hearing. We appreciate your presence. Another stakeholder? Dr. Pugera Mapon.
Good morning, honorable members. I'm Dr. Pugela Maponia from the Agriculture Research Council in Pretoria. Thank you.
Thanks very much, Dr. Pugela Maponia from the ARC head office. Thanks very much, Dr. Maponia. Your presence really warms our heart. We really appreciate your presence. Next stakeholder, please. Next stakeholder. Ms. Molepo, can you check? They are all connected.
Yeah, thank you, Chairperson. We also have Ashley Doe. And
when let's start with the first stakeholder that you introduced. Where is it from?
Dr. Dima.
Yeah.
Well, Dr. Dima is from Vembe. Chairperson, can I get more details about Dr. Dima, because he just wanted to be part of the public hearings because he has interest.
Okay. No, it's not a problem. If he just entered in his individual capacity, it's still fine. Ms. Lugege, your hand is up.
Thank you, Honorable Chair. We have Sanda Bonetwera from Vembe who's going to join us shortly. He's just having technical challenges. Thank you.
Thank you. Dr. Dima, Dr. Pukela Maponya, Bamsanda. Who else?
Ashley Daw, she is from EWT. I thought she would be able maybe to give us full details about herself. But it looks like, I'm not sure if she's not able to hear where she is. I'm not sure.
Is she connected?
Hi, can I speak, please?
Yes, Ms. Korisha Pillay.
Okay, good morning, Honorable Chair, Honorable Members, and Honorable Stakeholders. I am Kirishka Pillay, and I am speaking on behalf of Ms. Ashley Daw. She's just busy in the field at the moment, but I will be speaking on the behalf of EWT, which is the Endangered Wildlife Trust, on today's meeting.
EWT. Endangered Wildlife Trust.
Yes, that's right. Thank you.
Thanks very much. You are welcome. Your presence here really warms our heart. We look forward to a fruitful discussion with you, especially the organization that you represent.
Okay, thank you so much, Chair.
Okay. Honorable members, there we are. Now we know who's who. We're not going to, it is not our anticipation to, Ms. Malawi, your hand is up.
Honorable Chair, Chief A.S. Netshwera has joined us.
Bamsanda Netshwera. Okay. We really appreciate their presence. We really appreciate their presence. Sanda, you are welcome. Your presence really warms our heart. We're looking forward to a very successful public hearing in your presence and looking forward to your valuable contributions. Without much ado, honorable members, we're going now to item number 3. If you allow me, just to take you through the purpose for this public hearing. We are meeting honorable members to deal with the 2 bills. The first bill is the National Forest Amendment Bill, and the second bill is the National Environment Management Laws Amendment Bill. In terms of the National Laws Amendment Bill, National Environment Management Laws Amendment Bill, NEMLA, we deal with various pieces of legislations, the NEMA, the National Environment Management Act of 1998, the National Environment Management Act Protected Areas of 2003, the National Environment Management Act Biodiversity Act of 2004, the Air Quality Act of 2004, and the Integrated Coastal Management of 2008, and lastly, the Waste Act of 2008. So when we say these are the National Environment Management Laws Amendment Bill, is because in it we have various pieces of legislation in it. So we are here because as you'll be receiving the briefing on the bill, we really need to get a public inputs. We are expected in terms of Section 118 of the Constitution of the Republic that whenever the law is to be passed by the National Parliament of the Republic, together with the National Council of Provinces, ourselves, the provincial legislature, we need to go an extra mile to get the views of the public so that our laws reflects not only the aspiration of lawmakers, but the aspirations of the lawmakers are in tandem or on the same wavelength with the wishes of the public, so that there is no contradiction between us as the representatives of the people and the people on the ground. So in terms of this section of our constitution, we are really expected to ensure that we conduct these public hearings, and we will be conducting this public hearing to get a feedback so that we can get a mandate, a negotiating mandate to the National Council of Provinces. So without much ado, honorable members, I'm going to request that we get a briefing about these bills. The agenda is projected there. We'll get the briefing first on the National Forest Amendment Bill. And then from there, we'll have questions and clarification on this bill. And the stakeholders will make submissions. And then after making submissions, we'll then move to the National Environment Management Laws Amendment. And then when we're done with that, we'll get questions and clarifications. And after questions and clarifications, we'll then move to submission by stakeholders. So without much ado, honorable members, I'm going to request Ms. Maloza to take us Ms. Malota to take us through the first National Forest Amendment Bill. National Forest Amendment Bill. I think the presentation is going to be projected there. We can all follow. I'm going to implore that all of us, we must ensure that we mute our mics and then we mute our cameras to allow a seamless presentation. And then from there, when she's done, she'll indicate and then we'll come in, all of us. Without much ado, Ms. Malota, the platform is yours. Thanks very much.
Thank you, Honorable Chairperson. I will be dealing with the National Forest Amendment Bill, and I will not deal with the background and all the other issues that were dealt with by the department when they were presenting the bill to the committee. We'll just go straight to the objectives of the bill in terms of the slide that is about page 7 of the presentation, which sets out clearly the objectives of the bill, which are, among others, to provide definitions, for example, for woodlands, to provide for trusteeship, to increase the measures provided in the Act to control and remedy deforestation. And they are still continued as well on page 8, because they now establish new penalties and new offenses. And they also provide for appeals against some of the decisions that some of the delegated authorities might take. I will also not deal with the process that was followed by the department on page 9 and page 10 and 11, 12. I will just go to page 13, which now deals with the bill clause by clause. In terms of the bill, in terms of clause 1, there are new definitions that the bill is bringing about. One of them is assignment, which is flighted there on the screen, but mainly this new definition is brought into assisting the interpretation of the Act. So we'll go to the next definition, which is the appeal committee. It is also a new definition in the bill as well, and it is also meant to assist in the interpretation, because initially there was no definition for the appeals committee. And we will also move on to page 15, which is also a new definition. I beg your indulgence. It's not a new definition. They are broadening the term natural forest to include some of the vegetation that was initially excluded in the Principal Act. So there is the definition for natural forest, and all the words that are underlined are the new insertions. And there's also a new definition, as I've already indicated, relating to woodland, and it is also seeking to broaden the definition in order to cater for some aspects that were not there in the Principal Act. And then we will move to clause 2 of the bill. It is a new insertion as well. This proposed amendment, it seeks to clarify where the nation's resources are to be managed, where this trusteeship is supposed to be. If you can just quickly look at it, it also states that the national government as the public trustee acting through the minister, then it sets out the things that must be ensured. I will move to clause 3. I will just request the Honorable Chairperson to inform me if I'm moving too fast. Then we will move to clause 3, which seeks to amend section 7 of the Act. In terms of this clause, the new insertions are mainly there to cater for vegetation that was previously excluded. If we were to go and check at in the second column at A, those are the new wordings that the bill is seeking to introduce in order to cater for things that were not included in the Principal Act, mainly indigenous forest vegetation or any forest product derived from vegetation. We'll Clause 3 also seeks to amend Section 7, subsection 5 of the Act to provide for directives where there is damage. So in terms of non-compliance, it also provides for measures that the minister can implement to deal with the destruction of natural forests, the prohibition thereof. Then we're still on Clause 3, Section 7, subsection 6. It deals with steps that may be taken if there is non-compliance. The steps are clearly set out in the second column. One of them, which is worth noting, is the fact that in Roman figure 2, that they might be able to recover consequential damage or costs from the person concerned. Then we can move to Clause 4. Clause 4 of the bill seeks to amend subsection 8, subsection 8, tongue-tied. Section 8, subsection 3 of the Act. And in terms of this is a new insertion. It seeks to prohibit any activity in the protected area. If we are to look at it, it considers that a person may not conduct any activity in a protected area which is inconsistent with the conservation and recreation of any other management objectives of that area, except under circumstances that may be determined by the minister. Clause 5 deals with amendment to Section 14(6). It seeks to add a new insertion into the clause. Basically, the clause seeks to provide powers to the minister to terminate activities while investigations are still going on, because at times there might be a need for an application to stop activities that are harmful to the environment, but while the application is going on, then the person might still be continuing. So this seeks to cover that gap, that the minister may have powers to stop activities while the application is going on. Then we'll move to Clause E6, which seeks to amend Section 15. In terms of this amendment, it seeks to minimize costs for compliance promotion that is incurred annually during the publication of this declared national list of protected trees. Then we will quickly move to Clause E7, which is an amendment to Section 16(1) of the Act, which also provides that registration by the minister in the deeds office of a part or a protected area in order to, this is meant to align this Act to NEMA and other legislations as the National Environment Protected Areas Act of 57 of 2003. Clause 8 seeks only to deal with syntax, which was basically to deal with what I would basically say in an ordinary language is English, because if we were to look at that clause, instead of saying is being, it's saying or has been. So that's why they're just indicating it as syntax. Then we will move also to Clause 8. Clause 8 of the bill deals with Section 17(3). This is a new insertion, and it is seeking to declare powers, emergency powers of the minister in order to prevent continued deforestation. And we will also deal with 17(4), which is also a new insertion into the Act, that it also seeks to give the minister powers to issue directives in case of non-compliance. And Clause 9, which seeks to amend Section 23(4) of the Act, it seeks to assist government to prohibit mining activities in state forests in order to promote sustainability. Therefore, if we were to read the new insertion, it says no person may engage in any prospecting or mining activity in a state forest except in terms of, and then it sets out the provisions. We will move to clause 11. Clause 11 seeks to amend section 35. Section 35 of the bill deals with members of the council and who are not full-time employees. So it basically deals with their remuneration, because now it seeks to include both committees relating to sustainable forest management and forest access. I will move to clause 35, also still dealing with the issues of remuneration. So I will just move to clause 12. Clause 12 just extends the advisory function of the committee. This committee that is called the Committee on Forest Access. It was initially meant to advise only the minister, so now it is just being extended to also be able to advise the department. We'll go to clause 13. Clause 13. Clause 13 is mainly a consequential one relating to that advisory function, so I will just move to the next clause, which is clause 14. Clause 14, I would propose that we also move to the next one, which is the insertion in section 57A. It's page 34 of the slide. This new insertion is now bringing in a new appeal procedure that should be followed. And it also deals with vacancies in the committee and how the appeal committee should conduct its investigations and how it should consider these matters. We'll move to clause 16, amendment of section 58, subsection 6 of the Act. It's one of the things I indicated in the introduction that one of the objectives of the bill is to now set up penalties and new fines. One of the things that is being done in the terms of the bill is to strengthen the enforcement. If we were to look, they're changing the amount of the fine and the period of imprisonment. It is, the fine is no longer 50,000 rand, it's now being extended to 10 million rand. And the period of imprisonment is moving to 10 years. If we go to clause 13, which is section 58, subsection 8, it still deals with penalties for any offense in terms of this act. It says one of the consequences is that the license may be revoked or suspended. So it is dealing with issues around enforcing the provisions of the Act. If we were to go from clause 17, basically to clause E20, which is about the next, just want to quickly check, it's about the next 4 pages, up to page 40 of the slide. It is provisions that are seeking to strengthen the enforcement powers or in terms of the Act. It is indicating which other areas will now be considered as offenses and in terms of the categories of those offenses. So I'm going to move, as I've already indicated, up to section E20. It's basically provisions that are strengthening enforcement of the Act, which were gaps that in the previous Act the department has realized. Up to E20, it's page 42 they're still dealing with enforcement provisions to make sure that the delegated officials who have to enforce some of the provisions of the Act are able to implement and enforce the Act. And Chair, I would say that brings me to the conclusion of the presentation on this bill. And thank you, Honorable Chairperson. I will pause here and wait for your direction.
Thank you very much. Thank you very much, our legal expert, Ms. Malota. And thank you very much for taking us through and the manner in which you took us through. At least it makes it easy for us to actually follow. Honorable members and colleagues, I'm going to allow you an opportunity in line with the program to make questions and for clarifications. Honorable members. Our stakeholders, this is more of your platform now. Honorable Smalley, you are noted. I would prefer you stakeholders to now engage. The presentation is made most importantly to you there. I'll be coming back. Allow me to take Honorable Smalley. Honorable Smalley.
No, Chairperson, thank you. I think you covered me when you said it's more for the stakeholders, and I just think because we are dealing with two bills, I'm not so sure if the stakeholders that did make amendments to or are suggesting certain amendments that you would just make reference either to say it is this amendment bill that we are talking to, so that it's recorded accordingly. And then I'll speak after some of the stakeholders might have engaged, but I've got comments right at the end. Thank you, Chairperson.
Okay, thanks very much, Honorable Smalley. Yeah, honorable members and colleagues, there are the various clauses which seeks to amend the National Forest Act. So the analysis is there clause by clause, so that you are able to follow. In terms of this section, this is what is being amended. In terms of this section, this is being amended. Yeah. If you can go back to the first slide in your projection, and then so that you move slowly down, you go to the first slide there. First slide, yeah. Up again. Go up again. There you are, National Forest Amendment Bill. Introduced by the Select Committee on Land and Mineral Resource on the 2nd of June 2020. Let's go down. Yeah, that's just the presentation outline there, the acronyms there. You go down again. Those are the objectives of the bill. Go back. Yeah, objectives of the bill. Down again. There's one bulletin that I know will be of great interest to Honorable Makrupeta. The last bulletin there. The previous act did not have this part, honorable members, the promotion of equity by inclusion of youth, women in the National Forest Advisory Council. I think is one of the most important aspects at this point that will be now integrated into the Act, into the National Forestry Act, because the National Forestry Act, especially in as far as the Forest Advisory Council, was not very explicit in terms of representation of women and youth. Yeah. And people with disability. Let's go down again. That's the process that followed. Let's go down again. Down again. Down again. Down again. Close by close. There they are. Down. They are down. 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 Let's go to the last slide. Down. Down. Thank you. Oh no, are we in the last slide now? Yes. Yeah, colleagues, any hand on this bill? Any input? Yeah.
Just trying to get.
Honorable Smiley, you can shoot, no?
Yeah, no, thank you, Chairperson. I'm just going to add comments. Look, the consequences of this bill was to seek and to provide certain definitions so as to bring clarity to the natural forest and woodlands areas. We know that our province have got vast forest areas, especially in the Vembe region. And it also provided for public trusteeships on the nation's forestry resources, as well as it has increased sustainable forest management. It also gives remedy to the deforestations and provide for appeals and to reinforce the penalties of these offences that is committed in reference with this Act. We also take note that the land reform possibilities is great. If this forest land could be transferred to communities, and therefore the Democratic Alliance does support the amendments to this bill put forward. Thank you, Honourable Chairperson.
Thanks very much, Honourable Smale. Thanks very much. Thanks very much. There you are, the Honourable Smale. What he's simply saying is that they find the bill to be in line, and they associate with the aspiration of the bill, especially the protection of the woodlands, protection of our forest, and so forth. So that's the input. I'm going to allow any other input, and then from there I'm going to repeat. Any input? Honourable members, you are at liberty also to air your views. Should I assume we are on the same page so far, together with our stakeholders, so far as the bill is concerned? Indication 1, indication 2, indication 3. I think we jointly with the stakeholders, I think we're on the same page. We are supporting this particular amendment. We're supporting this particular bill and the amendment to the National Forest Act. So without much ado, I'm going to request that we pass, and then we go to the next bill, National Environment Management Laws Amendment Bill. Ms. Malota, once again, the platform is yours.
Thank you, Honorable Chairperson, once again. I will just provide a brief background so that we all understand the purpose of this bill. In terms of NEMA, we call it NEMA in short, the National Environment Management Act. I would say it's one of the main, it's a main legislation dealing with the environmental laws. And there are other legislation that NEMA normally affects, and they are being referred to as SEMA, Specific Environmental Management Acts. So when I deal with the presentation, I will refer to it as parts to indicate that this part deals with NEMA or with waste management and so forth. Basically, this bill, the NEMA bill, seeks to amend about a few pieces of legislation. One of them will be the National Environmental Management Air Quality Act. It also seeks to amend provisions in the National Environmental Management Biodiversity Act. This bill also seeks to affect some provisions, to amend some provisions in the National Environmental Management Integrated Coastal Management Act. It also affects some provisions of the National Environmental Management Protected Areas Act. And then it will also affect National Environmental Management Waste Act. In brief, that is the purpose of the bill. But now I will just go through some of the clauses. I will be on page 4 of the slide. In terms of NEMA is seeking to bring some new definitions. For example, one of the definitions that NEMA is the bill is bringing into existence is the one for financial provision. And then there are certain definitions that are being brought in, what we would call, they are there to support some of the new provisions in the Act. For example, municipal council, municipality, to rehabilitate a municipal manager. And then there's something new that the bill is also seeking to bring in terms of Section 2 of that Act. Now there's a new principle that is being added, which is to promote the full participation of Black professionals. This is becoming one of the principles of the bill, of the Act, if this bill is passed into law. And then most of the issues in this bill deal with Section 24 of NEMA, which deals with environmental authorizations, and it sets out who is the competent authority, and deals with structures like environmental management instruments, and it also deals with the prohibitions and restrictions and powers of the minister. So if we are now to start going to the clauses, we will go to clause 3, which is basically amending Section 24, which I was referring to. There are several amendments that will be brought about by the amendments that the department is proposing. One of them will be to clarify the competency of the minister responsible for mineral resources. It will also provide for more flexibility in the use of environmental management instruments. And it will also be providing for conditions and the requirements that should be in those instruments. I will not go through all of them because they are already flighted on the screen, but I will go to 24G, which is clause 5 of the bill, which now indicates that in case where a person takes ownership of a property in good faith and was not aware that there are structures that are, or development that was not approved, which is an unlawful structure, now these new amendments will seek to assist this person to get the development or the activity to be authorized. One of the issues that these new amendments will bring, it will now increase the administrative fines for non-compliance, which were at 5 million, it will be bringing them to 10 million. And clause 6, which seeks to amend section 24N, dealing with environmental management programs, will now allow that these programs should be regulated in regulations and no longer in the Act. So some of the provisions that were in the Act that were dealing with the environmental management programs will now be dealt with through regulation. So it is empowering the minister to be able to do that. And then section 24O, which deals with environmental authorizations, now provides for the requirements that should happen for consultation during the consideration of these environmental authorizations. We'll move to section 24P. Section 24P deals with financial provisioning that is required for progressive rehabilitation. In terms of this, in terms of this provision, it now enables the minister or the MEC to be able to prescribe instances where financial provision might be required in terms of environmental authorizations. And it will also be indicating what this financial provision should be providing for. For example, it includes progressive rehabilitation, decommissioning or closure and post-closure activities to try and rehabilitate the environment. We'll move to section 24, which I just want to check the summary that I wrote. Or section 24 PA, it now provides for a person who is deemed to be a holder of an environmental authorization. It gives the responsibilities that this person must now undertake. One of them will be to maintain and retain the financial provision until a closure certificate is issued. One of them will be to submit to the minister responsible for mineral resources the audit report, and in the case of a mining permit, every 3 years. We'll move to, just want to quickly check my notes as I'm speaking. We'll move to section 28. Which deals with the duty of care and remediation of environmental damage. In terms of the Act, only the Director General, the DMRE, and the HODs had power to issue certain directives, but now the bill now seeks to add municipal managers to this particular group of people who can issue those directives in terms of clause 12, section 28, that is. And it also provides for remedial measures that the authorities have to undertake, which can be anticipatory as well. That is, if I were to maybe just provide a brief example, if the authority is of the opinion that they're anticipating further damage to occur, then it gives them powers now to be able to invoke some of the provisions of the Act to claim for provision. I will now have to go slowly to get that proper, to provide for financial provision. Thank you very much for your patience. We will move to section 31A and 31Q, which is basically clauses 13 to 19. They deal with appointment of environmental management inspectors in the different spheres and all the officials that have to deal with compliance and enforcement of NEMA. I will move to which is page 13, clause 34. Clause 34, which is amending section 43, deals with appeals against decisions taken by delegated authorities in terms of NEMA and the CMAS. It's page 13 of the slide. And one thing that is worth noting in terms of clause 34 is that it indicates that an appeal will not automatically suspend some of the directives or administrative enforcement notices, because in ordinary circumstances, the presumption is that appeal automatically suspends some of the processes that might be happening. So it is worth noting that the bill is clarifying that that is not the case. And the bill is also clarifying offences and penalties in terms of this clause. And it also introduces some of the new offences and penalties that are associated with non-compliance. I will now go to, will say it's part 2, amendments that will affect the National Environmental Management Protected Areas Act. There is section 48 of the NEMPAA, which is the acronym for the act that I've already indicated. Subsection 4 of section 48 of that act now provides for criteria under which the permission issued by the minister, it should comply with. And it also indicates that the minister may require any further information that he or she deems fit or necessary before taking a decision. These provisions will also, of this NEMPAL, will also be amended in section 57. This is mainly a governance issue to say that now the Act will also provide that the CFO should be a member of the board. And it will also now, there's also an amendment to section 89 by an insertion of a new section which will be 2A, which will now create offences for people who undertake a restricted activity in contravention of the Act. And some of them are mainly to correct somewhere where they have done incorrect references. And I will also now move to part 3, the amendments that will affect the third piece of legislation, which is the National Environmental Management Biodiversity Act, as referred to as NEMLA. One of the things that this bill, the NEMA bill, will do, it will extend some of the objects of NEMA. And one of them that will also, of the powers that will be extended is the power of the minister to make regulations in relation to the well-being of fauna biological resources. And the bill now also gives the minister powers to prohibit any activity that may negatively impact on the well-being of fauna biological resources. This bill it will also affect the NEMLA Act in this manner. There is a court judgment that the department also had to now comply with. In brief, the issue is that in terms of common law, wild animals are classified as things that belong to no one. there's a Latin term that we use, they call it res nullius. And that means that for the government or for the state, it's a challenge if wild animals have escaped. So in terms of that court judgment, they were expected to now pass laws to legislate on that issue. So one of the issues that the bill now is seeking to deal with is state trusteeship of biological diversity, which is mainly, as I was indicating, which affects wild animals, their ownership. I will continue on to the next slide, which is on page 16, to indicate that the bill also gives the minister some powers to prescribe measures to control or eradicate listed invasive species. And one of the things that the bill also does is the same that was done in the previous act. It also seeks to deal with governance issues, that the CFOs should be members of the board of the South African National Biodiversity Institute. I will move to slide 17, which is basically part 4 of one of the pieces of legislation that will be affected by the NEMLA bill. It will seek to amend provisions of the National Environmental Management Air Quality Act. I don't want to tie my tongue and use that acronym for now, but what I will say is, in terms of the Air Quality Act, as I've indicated, Section 22 is being amended. And now it shows the consequences of conducting some of the unlawful listed activities. Some of those activities that they are providing for are those that happen when a person does not have a registration certificate under the Atmospheric Pollution Prevention Act, and where a person has one. So the bill sets out those procedures in addressing some of the non-compliance issues and also the fines, as indicated in the slide. I will move to page 18 of the slide. It still deals with some of the proposed amendments that will affect the Air Quality Act. One of the things that the bill is now introducing is that it will enable cooperative agreements between the municipalities, MECs, and the minister on who should be a licensing authority for some of the applications. Because in terms of the act as it was as if the presumption was that it will only be the minister who will be a competent authority. But now, where there are issues of overlapping of powers and responsibilities, now the bill seeks to clarify those. And the bill also now sets out the appeal regulations that will be applicable to appeals against air quality decisions. I will move to what I will call part 5, one of the pieces of legislation that will be affected by the bill, which is now the National Environmental Management Integrated Coastal Management Act. Sorry. In terms of the provisions of the bill, one of the provisions that will be affected will be how they allow the issuing of notices for the removal of structures that were erected prior to the commencement of the Act. And now this bill now seeks to clarify that in terms of the Act, yes, it will apply retrospectively. It means people who had been allowed to continue with some of those structures that were allowed to erect some of those structures, they will be deemed to have been authorized in terms of the Act. And it also deals with processes relating to appeals. I will move to part 6 of one of the pieces of the legislation that will be affected by amendment of NEMA, which is the National Environmental Management Waste Act of 2008. The NEMA bill will now bring in new definitions into this piece of legislation. Some of the examples are there on the slide, which is page 20. Building and the definition of building and demolition waste, the definition of domestic waste, the definition of hazardous waste and inert waste, and the bill now brings also a new definition of what we call residue deposit, residue stockpile, in order to align it with NEMA and the Mineral and Petroleum Resources Development Act, which is the MPRDA. The bill also provides clarity on where will residue stockpiles, these are issues relating to mining, residue stockpiles and residue deposits, where will they be regulated? Because they are moving them from the provisions of the Waste Act to the NEMA Act. I will go to now slide 21. Slide 21, the bill will also establish what we refer to as the Waste Management Bureau. This bureau will be a juristic person, it will have a board, and it also, which will report to the minister. And then it also sets out the powers of the minister in supervising this entity. The bill also amends the following sections: Section 34F, 34G, 34H, 34I, J, K, and L of the Waste Management Act, and sets out which these are mainly administrative provisions, because they will be setting out the powers of the Waste Management Bureau, the composition, the membership, the qualifications of the members of the governing board, and the procedures in terms of which they will be appointed. And the bill also introduces one provision that the minister must keep a national register of all contaminated land. We'll continue to section 43 of the Waste Management Act, which now identifies the licensing authorities for the different waste management licenses. Especially, in the instance where it indicates that the minister responsible for mineral resources is now being defined as the licensing authority to deal with waste management licenses for waste management activities that are related to exploration or prospecting of a mineral or a petroleum resource. One of the issues that the bill will be bringing into the Waste Management Act is the powers of if the MEC is not able to issue a license within the prescribed time frames, it now empowers the applicant to be able to move to the next step, which is maybe to request the minister to take a decision. In terms of our presentation, on page 23, the clause 72 and 73 are what we call in law, we call them consequential amendments, in that they have to amend some of these provisions to bring them in line with some of the definitions that are being introduced. For example, if we were to look at clause 73, it now deletes some of the powers that they were given to the minister previously because now they will no longer be regulated in terms of this act, but some of those powers are moving to the NEMA Act. I just want to quickly check. If we move to slide 25. Slide on page 25, in clause 12 of the NEMA Act. They are now trying to bring what we call legal certainty, legal clarity on whether environmental management plans or environmental management programs that were approved prior to the date in question, which is the 8th of December, whether they are still valid or not. And now they are bringing it clear in terms of that there's a provision now which states that any approval that was obtained before this date is valid. The only difference is if the approval was not sought before that date, then the person cannot claim to have a valid right. And this brief explanation is bringing us to page 26, which now also provides that the minister, which will be responsible for mineral resources, may direct a permit holder or a holder of a right to upgrade their environmental management plans if their operations are likely to result in unacceptable pollution or degradation, ecological degradation or damage to the environment. And it also gives the minister powers to issue environmental authorizations once these deficiencies have been corrected. If we go to page 27, 28, those are basically what we call transitional arrangements that are in place while they are waiting for these bills to be processed. That's what we call them. And I will pause there, Chairperson, with your permission. Thank you very much.
Thank you very much, our legal brain. Once again, allow me to thank you and request our stakeholders to pose questions. Honorable members are equally allowed to pose questions and to questions of clarity, and from there we can move to inputs. There is the stakeholders is a presentation on the amendments of the National Environment Management Act of 2008, popularly known as NEMLA, and various specific Environment Management Act, Waste Management, Waste Act, Biodiversity Act, Coastal Management, Integrated Coastal Management Act, the National Environment Management Act, Protected Areas, and Air Quality. There is a presentation. Feel free to engage. Sandago Netsera, your hand is up.
I've got this simple question, which maybe it could have been covered, but maybe I couldn't pick it up. The question is with regard to sand pitting.
Sand pitting.
Sand pitting. In our rural areas, we've got a lot of sand pitting taking place.
Yeah.
Majority of the people are building houses, as we all are aware. And unfortunately, people are expected to be able to provide provide sand, those that are having their companies in terms of delivery, sand and bricks and all those stuff. So I want to check whether there are certificates that are to be issued for people to be able to mine with sand. Because from where I am, we've got a lot of challenges with regard to this. We've got a lot of dongas that are not rehabilitated. People are selling their fields for the sake of them to be able to make money. And as and when we look, we're realizing that a lot of our land is no longer going to be usable. And if this is not being addressed, we may have a challenge in the near future. Thank you, Chair.
Thanks, Musanda Buneswera. Our legal expert will be coming with the answers. We will also be assisting in terms of providing answers. Honorable Smale, you are welcome to come in.
Thank you, Chairperson. Just a point of clarification to the legal experts, because I'm just trying to understand if it is some of my issues that I will be raising are being dealt with either within the various types of legislation, or then will be taking up into the regulatory framework on behalf of government. So when one looks at the clauses one towards the definition, and we look at the financial provision that has been taken up in that portion, we know from a historical context that a number of our mines, and this will maybe talk to the Musanda's issue, have been closed due to insolvency, or people cannot be able to rehabilitate the pieces of land. I think what I would want to do is propose that a mechanism must be provided for in the NEMLA that will ensure that the financial provision is safeguarded against being paid out, whether in the case of the insolvency of a mine or any other circumstances. It is therefore proposed that a financial provision may only be disbursed once the prior consent of the competent authority has been obtained. And in this case, it will be either the MEC or the minister or the government department in that regard. The second one is the definition to mitigate. Now, the proposed definition to mitigate is very narrow, and it should be in line with within the mitigation hierarchy, and includes avoidance as well as remediate or rehabilitation and the offsets thereof. So I'm not so sure if those things have been put into place. Sorry, I must just go to my notes. Okay. The new section 24C13 is supported, but it should also propose that that its amended follows if the competent authority or licensing authority contemplated in subsections 11 or 12 is the same authority that considers and decides on the application for an environment authorization under this Act, and the application under a specific Environment Management Act, an integrated decision may, it says may, but I say I was considering it should read must be issued in accordance with Section 24L of this Act. And I just would want to see or hope that it aligns those matters. There was one other further section. Yes, Chairperson.
Oh, you know, you can proceed.
There was one other section that it wasn't clear, and I think it falls under 24G3C. When the MEC or the minister might puts authority through that something must be demolished or removed. In that case, it has got to be in the cost of the applicant, and that any infrastructure or structure constructed or erected or developed in respect of the listed or specified activity, it must be clear to whose cost it should be. in the event that something of that nature does take place. I was happy with that. When clause 17, section 31D, subsection 3A refers with any applicable duty provided for this act, it is however unclear which duties are being referred to. Will those duties be taken up in the regulatory framework that will be published, or does it mean that we have got to look at that clause and making sure that it's being redrafted? I'm just asking from a legal perspective point of view or guidance in that in that line. Sorry, Chairperson, there's quite a lot. Section 41.3 of the NEMLA or the Act provides that a provisional atmospheric emission license is valid for a period of 1 year from the date of commissioning of the listed activity and may be extended for an additional 1 year period on good cause shown to the licensing authority. I would argue or would propose that if section 413 is amended as follows: a provisional atmospheric emission license is valid for a period for 1 year from the date of the commissioning of the listed activity and may be extended for an additional 1 year, a period as determined by the licensing authority on good cause shown. So it must bring in a period as determined by the licensing authority. So when that issue is in the air and it's not being finalized, that the good cause must be shown, and if it must be amended in that regard. Chairperson, those were my 2 or 3 things. I think some of the things were clarified by the speaker, and I want to thank her for her clarification in this regard to thus far. Thank you, Chairperson. Chairperson, I have concluded. I'm not so sure if there anyone else that needs to go. I can't hear you.
Okay. Oh, thanks very much. I was speaking alone. I did not unmute. I'm sorry for that. I was saying to Ms. Malota that first I wanted to check if there is any other hand. And I was suggesting that I was assisting her to capture. I have captured the question on sand pitching from Nsanda Bonetsera. I have captured the question on financial provision versus rehabilitation and insolvency, which is a very, very great concern. I have not captured the last question from one of Ms. Malo, but I hope Ms. Malota would have captured it. So I'm going to request Ms. Malota that let's try to respond to the questions that have been raised. If there is a follow-up or if there is anyone who wants to raise any other question, we'll take it from there. Ms. Malota, over to you.
Thanks again, Honorable Chairperson. In terms of the issues raised by Vamsanda regarding sand pitting, to the best of my knowledge, if I remember well, the piece of legislation that deals with issues around this is the one dealing with mining, which is the Mineral and Petroleum Resources Development Act. It deals with some of the issues regarding, because it is dealt with under issues of prospecting. So what I would advise would be that if maybe the Bamsanda can contact the relevant department that deals with issues on mining to get their assistance in terms of enforcing licenses around the area. Maybe that might assist. In terms of the issues raised by Honorable Smale, I have noted them. I will just ask for assistance if maybe I might have skipped one. But in terms of clause 1, my understanding is that the Honorable Member has provided inputs to say, in terms of his opinion, this is a narrow definition and it should be broadened. And I've captured all the areas that he has proposed around mitigation and rehabilitation and remediation. And also in section 24C, what he has raised, for me, it's an input because he says it must not be may. He proposes that it should be prescriptive. It must say must. So for me, these are inputs that I would proceed to include in the inputs from this hearing going forward, as well as the issue when he is also asking about to whose cost it should be. It's one of the issues that we will also be putting forward as an input. I'm not sure if I have missed some of his inputs, and I will just request any person who has them to maybe just bring them forth. Thanks, Chair.
Okay, thanks very much. Honorable Smale, you are captured then?
Chairperson, I have been captured. No? It is correct. It's just making sure that those things are there, and that usually within all of these ambits of the law, I'm just trying to remove the grey areas for the department or the minister to make sure that it is grey. That it's taken account, especially when it comes towards the cost, because some of these things are going to require a decision by the relevant authority at some point, and the issue about costing must be cleared. So thank you very much. I think the legal advisor has captured me correctly, so thank you.
Okay. No, thanks. On the question of self-pity or self-ending, I think Ms. Malota is right. In terms of the Mineral and Petroleum Resources Development Act, it makes illegal for anyone to conduct any sort of mining, including sand mining, without a permit. Now, one of the spirit of this act, including this one, especially the previous one, the Forest Act, one of the spirit is that as a country is that we as the people, we do not take ownership of our own resources. In the sense that when we see people who are doing sand-pitching or sand mining, we know that they are doing so much damage to the environment, and we do not often report them. Anyone who does any sort of mining should, without a license, should be reported to the relevant authority. And in this regard, if someone in your area is conducting that, you must communicate with the Department of Economic Development, Environment and Tourism. Or you can even report to the municipality, they'll assist with that particular process. That is done to ensure that anyone who does mining, there must be a rehabilitation plan. That is why you have so many dongas, especially in our rural areas, where you then have so much dongas. So as Ms. Malota will have advised, I think I would advise that in case you have such cases, let's report them, let's raise them to the Department of Economic, Environment and Tourism. There is a section that actually deals specifically with monitoring the illegal mining, especially the sand-pitching. So I'm happy you have raised that particular concern. Let's deal with it that. And if you are unable to reach them, the very colleagues who assisted you, Mr. Malawi. Ms. Malawi.
Honorable Chair.
You might need to interface immediately after this public hearing with Chief Natswera, so that you assist them to link up with the department to report any form of illegal mining in their area, because it's true that if we do not attend to it, it ends up damaging the whole area, and children end up falling into those pits because they are now not rehabilitated, and so forth and so forth. It must be done. It must be done. Mine sandpicking must be done in a manner that takes cognizance of the fact that if we are done mining on this area, it must be rehabilitated. And the law protects us, and as the traditional authority in that particular area. Please, Ms. Maladi will link you with the relevant people in the department to assist you to deal with that particular challenge.
Noted, Honorable Chair.
Thanks very much. Is there any other thing that I would have missed? Honorable Smala, you said you are covered in terms of the response by Ms. Malota, and Ms. Malota, you said you'll find a way of including some of those inputs that the Honorable Smala had given. Without much ado, I'm going to request if there is any other thing. Our stakeholders, honorable members, indication 1, indication 2, indication 3. It means that we do not have any other thing on this particular subject, and then I would assume that we are done with the inputs on the 2 bills, the National Forestry Amendment Bill, National Environmental Management Laws Amendment Bill, and therefore we'll take the submissions as made and then integrate them as part of our. Ms. Pillay, allow me to give you a space before I move. Yes.
Yes, please. Thank you, Chair. Again, I am speaking on behalf of Ms. Ashley Daw, who is the Wildlife and Law Project Manager at EWT, which is the Endangered Wildlife Trust. And the Endangered Wildlife Trust has given extensive comments on NEMA, NIMBA, and the National Forest Amendment Bill. And we are happy to follow up and discuss any of these points further. Due to time constraints, I would like to use this opportunity to discuss the proposed definition of well-being under NEMLA, as it will create confusion, and we would like to raise our concerns over this, and we would like to raise the following points. For many years in South Africa, wildlife regulation that would govern the use of wildlife and wildlife welfare has been seen as 2 mutually exclusive considerations, and perhaps even at odds with one another. The result is that wildlife use has often come at the cost of the welfare of many individuals of species. As such, we welcome the initiative to include welfare considerations in NEMLA. However, we are concerned about the proposed definition of well-being for the following reasons. 1, it is very narrow and limits well-being to health. 2, the scope of health is uncertain. Would it include psychological or psychosocial health as well? 3, the terms health and well-being themselves are 2 mutually exclusive terms, as is illustrated in our Constitution, and shouldn't be combined or used interchangeably as is proposed in the definition of well-being. We would strongly urge the term well-being be replaced with welfare, and this amendment carried throughout all the proposed amendments to NEMLA that relate to well-being. Animal welfare considerations vary from species to species, but would be reflective in how an individual of a species coping with the conditions in which it lives. Overall, an animal is in a good state of welfare if, as indicated by scientific evidence, it is healthy, comfortable, well-nourished, safe, able to express innate behavior, and if it is not suffering from unpleasant states such as pain, fear, and distress. In the alternative definition of well-being, well-being must be amended to address the challenges detailed above and be reflective of the definition of welfare above. Thank you.
Thank you very much. Thank you very much, Ms. Pillay. Ms. Pillay, can I re-verify that on behalf of Endangered Wildlife Trust,
Yes.
EWT, you have made that formal submission, right?
Yes, we have made a formal. We have the document sent through to Ms. Machidiso.
Ms. Machidiso, okay.
Yes.
Can I just hold it there? Ms. Malota and Ms. Malawi, I can confirm that we have the written submission of EWT, right?
Yes, I confirm.
Thank you. Thank
Thank
you.
you.
So, yeah, what we'll do, Ms. Pillay, is that as we finalize our mandate, we'll take to consideration the written submission that you have made. We really, really appreciate it.
Thank you so much, Chair.
Thank you very much. Honorable Smale, your hand is up.
Yeah, thank you, Chairperson. Just on regards to Mrs. Pillay's submission, from a legal point of view, in the submissions or the regulatory framework that will be published, I know that animals are being classified as Appendix A animals, which is your highly endangered species. I would argue that we do not lose track of making reference to that in that regard. I know that they are being taken up at other parts of legislation, especially at the hunting environment. But in the cases of this, I do think we need to make reference to that section of the safeguarding of Appendix A animals, but I do think that will mainly fall into the regulatory framework and not so much into the bill itself. But that's just my understanding of it. Thank you, Chairperson.
Thank you very much. What is going to happen, honorable members, is that we are receiving various inputs. Some of them are contradictory. Some of them are in sync. But what we're going to do as a committee is that, and other committees that are going to be dealing with this thing, is to create a harmony between, because the spirit is one, the spirit is protection of our wildlife, protection of our forest, protection of the environment, and that's the spirit and the spirit of everyone who contributes. So what we'll be doing is that going forward, there will be harmonization of all these particular views. So it should be a problem. We'll find a way of finding a middle ground, especially around, even including, of course, not limited to the definitions and so forth and so on. So I think we are in the same page. Let's proceed from that particular point. Am I getting support to proceed?
Yes, you have.
Thank you very much. Exhausted the question, clarification, and submission by stakeholders and everyone on National Environment Management Laws Amendment Bill. And then I'm going to proceed now to check if there is any announcement. Keruska, Pillay? Ms. Keruska?
Yes, nothing further, Chair.
Okay, thank you very much.
Thank you.
Ms. Mulapo?
Thank you, Chairperson.
There must just that be understanding. Is the hand up again, Ms. Pillay? Ms. Pillay, is your hand up again?
No, sorry.
Okay, thank you very much. So, any other, thanks for the announcement, Ms. Mulapo. Any other announcement, Ms. Malawi?
No other announcement, Honorable Chair.
No further announcement. If there is no further announcement, the next item on the agenda is vote of thanks and closure. I want to surely, on behalf of this committee and on behalf of the August House of the Limpopo Legislature, which we have always maintained is the voice of the people and the people must use it. I think tomorrow was just but another clear indication that indeed we are the voice of the people as their voice. We want to thank everyone who participated in this particular hearing. I want to thank all of you, our stakeholders. Musanda Vunetswera, we really are honored by your presence here. Dr. Pukela Maponya from the ERC, we really appreciate your presence. Ms. Pillay from the Wild Trust, Endangered Wildlife Trust, we really appreciate your presence here. Dr. Dima from the Vembe region. Who else am I forgetting? We really appreciate all of you, our stakeholders who participated. Honorable members, all of you who were able to join us today, we really appreciate. We know that you are on recess and you've taken your golden time to ensure that we push the agenda of the people. Ms. Malota, our legal expert, we really appreciate your inputs, your presentations and everything. Ms. Mulepo and Ms. Ligege from the public participation, we really appreciate the work that you have done, ensuring that the stakeholders connect. We want also to thank our communication team, Mr. Luani. We really appreciate the work that we have done. Our IT, we couldn't be here, Ms. Mudiba and Ms. Machubeng. We wouldn't be here if it was not you. We also want to extend our appreciation to our support team of the committee, Ms. Malavi, and our researcher, Mr. Neluweni, for making this possible. Honorable members, all of you, I want to deeply and wholeheartedly appreciate your participation, your contribution, and your presence. With these few words, honorable members, I want to take this opportunity to say thank you, and officially, Ms. Maroga, I shouldn't forget our NCOP liaison office, Ms. Maroga. We really appreciate. We want to really appreciate your liaising in this regard, and then that we have made it to this far. You report back that indeed the public hearing has taken place. We want to take this opportunity to say once again, thank you. And if there is no any other indication of anything that we are omitting, I would pronounce this public hearing officially closed. Can I get a yes for that?
Thank you, Chairperson.
Can I get an endorsement that?
Thank you.
Thank you.
Thank you.
Thank you. The public hearing is officially closed.
Thank you.
And thanks to everyone to have made it successful. Thank you very much.
Thank you.